Yeah. Good evening, everyone. And amongst us, we have Advocate Vinay Shraff, who not only deals with the advocacy as such, but his passion for prevention of animal cruelty is one of the takes that we thought that on the eve of Mahatma Gandhi's birthday, as well as of Lal Bahadur Shastri, why not we speak in respect of animal cruelty when the constitutional framers itself, in terms of Article 48, gives us the way and insights to look into it. Though on animal cruelty, it will be a much larger canvas. But today's session would be on the cattle smuggling and legal analysis thereof. And as we all know, those who have been connected with us, we bring speakers who have immense knowledge. Similarly, Vinay Shraff is a well-known name, not only in the advocacy part, but the way he takes things forward to make things simplified. He makes the blocks unblocked, just like a Rubik cube, that one can understand how things are to be sorted out and what are the ways and aspects that things can be looked. And I will ask Mr. Vinay to take over the baton and share his knowledge. Over to you, and we are thankful that you have accepted our invite.
Thank you, Vikasji. I'm extremely grateful that you have given me this opportunity and your platform to discuss and talk about the laws relating to prevention of animal cruelty and the laws which are relevant to ensure the prevention of cattle smuggling, which is widespread mostly in the border areas. The reason I wanted to talk about this subject is that I have seen in my practice, I have appeared across various high courts, like most of the bordering states high courts like Tripura, Assam, Odisha, Calcutta, Meghalaya. And I have also appeared before various magistrate and session courts. So in my experience, I have realized that the knowledge about the Prevention of Cruelty Act and the rules relating to the Cruelty Act is very low. Whenever I appear, I see that the lawyer from the other side are not so well versed with the law and the jurisprudence which have evolved over a period of time relating to this prevention of cruelty. Not only that, I see that even the judges, not only they do not have much idea about this particular branch of the law, but unfortunately, most of the time, they do not have the readily available books also to deal with such matters. So what we do most of the time is to carry a compilation which we hand over to the other side, which we hand over to the judges. And I also feel that a lot of knowledge of this particular branch of law is required to be disseminated in the society. So the society, while we are all very well aware of our, or in these present times, we are aware of our fundamental rights, but very little is known about our fundamental duties towards the animals. So I feel that it is extremely important that as a citizen, we know little bit about our fundamental duties also with respect to the citizens. Article 51A G, within bracket small g, it clearly states that it shall be the duty of the citizens to have compassion for living creatures. And while enacting Article 51AG and giving it the status of fundamental duty, one of the objects sought to be achieved by the Parliament was to ensure that the spirit and message of Article 48 and 48A are honored as a fundamental duty of every citizen. Article 51G, capital A, within bracket small g, enjoins that it is a fundamental duty of every citizen to have compassion for living creatures, which means concerns for suffering, sympathy, and kindness, etc. Further, Article 51 capital A within bracket H says that it shall be the duty of every citizen to develop the scientific temper, humanism, and the spirit of inquiry and reform. Particular emphasis has been made to the expression humanism, which has a number of meanings, but increasingly it also means sensibilities for our species. Humanism also means to understand the compassion, mercy for the animals who cannot look after themselves. So it is the duty of every citizen to look after the welfare and well-being of the citizens, and it is our duty to prevent the infliction of pain or suffering on animals. Therefore, if we read both Article 51A, G, and H, then we would realize that it is our fundamental duty to ensure the well-being of the animals and also to prevent the unnecessary infliction of pain upon the animals. So before I deal with the subject of cattle smuggling, which is my primary subject of the day, I would like to begin with a little bit of history of Article 48, which you see was incited to enjoin a duty upon the states to prevent slaughtering of the animals. While many of the states have brought out the law to prevent cattle slaughter, but unfortunately it is not implemented in the manner and the spirit in which it should have been implemented. But the most unfortunate part of it is that a very large amount of smuggling takes place mostly to the Bangladesh. Bangladesh shares over 4,000 kilometers of boundary with India, out of which 2,100 kilometers is shared with West Bengal. And 400 kilometers under South Bengal particularly is a very porous zone. And this is the South Bengal, some of the areas such as Hooghly, Ilam Bazar, Rampur Hat, Suti, Murshidabad are the areas through which the cattle are smuggled to Bangladesh. In fact, you would be surprised to know that almost 76% of the smuggling of the cattle takes place through West Bengal. And you see, the reason for smuggling to Bangladesh is mostly that there is a high beef demand in Bangladesh. Moreover, there are large beef processing units in Bangladesh to export to other European countries and US and other countries. So the cattle from states such as Bihar, Uttar Pradesh, Jharkhand, Punjab, Haryana, Odisha are brought to the markets in West Bengal, and then they are smuggled across Bangladesh border. Even though the government, through the help of the Border Security Force, has tried to prevent cattle smuggling over years, and the cattle smuggling has reduced in numbers, but still a lot of work needs to be done. Now here comes the role of us citizens and the NGOs to help the government in prevention of cattle smuggling. The question arises as to what and how we can help the government in prevention of cattle smuggling. So before I deal with how to prevent the cattle smuggling, it is essential for us to know what are the laws relating to prevention of animal cruelty. Then I will deal with how we as a citizen and how the NGOs can strengthen the hand of the government to prevent cattle smuggling in any form. And in fact, prevention of cruelty on any animal, not only cattle, prevention of cruelty on any animal in any form, in any manner, how we can do and how we can perform our fundamental duty. So first of all, we should know what are the relevant act and what are the relevant provisions or the rules to prevent animal cruelty. First of all, you must know that there is a Prevention of Cruelty to Animals Act 1960, which extensively deals with the laws relating to cruelty. These are anti-cruelty laws, and how, if any cruelty is done to an animal, then how the accused should be dealt with. Then there is Prevention of Cruelty to Animal Care and Maintenance of Case Property Rules. I'll just put in the chat box the relevant name of the relevant act and the rules for the benefit of the viewers. So this is the main act to prevent the cruelty to the animals. Then there was a rule which was introduced in 2017 to deal with Prevention of Cruelty to Animal Care and Maintenance of Case Property Rules 2017. I'll deal with the purpose of this particular provision in a short while. Then there is Transport of Animals Rules 1978. There is a rule called Prevention of Cruelty to Regulation of Livestock Market Rules 2017, which deals with how the purchase and sale of the animals in a marketplace has to be dealt with. Then there is also a rule called Prevention of Cruelty to Animals, Establishment and Regulation of Society for Prevention of Cruelty to Animals Rules 2001. Now, in terms of this particular rule, Prevention of Cruelty to Animal Establishment and Regulation of Society for Prevention of Cruelty to Animals Rule 2001, under Section 38 of the Prevention of Cruelty to Animals Act 1960, with a view to establish societies for prevention of cruelty to animals, in short, SPCA, in every district in the state. So the rule says that every district must have a society for prevention of cruelty to animals. But unfortunately, despite several orders of the Supreme Court and direction of the Honorable Supreme Court to all the states in the country, unfortunately, these societies for prevention of cruelty to animals are not yet constituted. So if the responsibility which is enjoined or given to the state, that look, establish a society for prevention of cruelty to animals, where you see the public at large of that particular district and respected citizens can be the member, and they can ensure the prevention of cruelty to the animals. Unfortunately, these societies are not yet constituted by the government, despite the rules being there and despite several judgments of the Supreme Court in place. So it is the responsibilities of the NGOs and the common man to ensure that the Prevention of Cruelty Act is implemented and regulated. Now I will take you through some of the important provision of the Prevention of Cruelty Act and the relevant rules before I go further. Vikasji, may I be permitted to share the screen or to show the relevant rules? It would be useful if I show to the viewers the relevant rules and the act, relevant provision of the act and the rules.
You keep on. I'm just allowing you that right. Just hold a minute.
Okay. Start off. So section 3 of the Prevention of Cruelty Act says that it shall be duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. So section 3 very clearly says that every person who has the charge of the animal or who is supposed to take care of the animal should take all measures to ensure the well-being of such animal and to prevent infliction upon such animal of unnecessary pain or suffering. Now, section 11 of this act has provided various manners which will be treated or deemed to be treated as treating the animals cruelly. For example, if any person... Hello?
Mr. Vinay, you can do the screen sharing.
Okay. Is it visible? This section 11 yes. I'm showing?
Yes.
So as you can see, section 11, it talks about what will be deemed to be treated as treating animals cruelly. If any person beats, kicks, overrides, overdrives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain or suffering, employs in any work or labor or for any purpose any animal which by reason of its age or disease, infirmity, wound is unfit to be so employed, then willfully or unreasonably administers any injurious drug or injurious substance to any animal, then D is very important. Conveys or carries, whether in or upon any vehicle or not, any animal in such a manner or position so as to subject it to unnecessary pain or suffering. Now, why I'm saying that this is so important? Conveys or carries, whether in any vehicle or upon vehicle or not, any animal in such a manner or position so as to subject it to unnecessary pain or suffering. So if any animal is transported in a cruel manner, then it will be deemed that such animal has been treated cruelly. Now, I would like to show you the rule, the detailed rule relating to the transportation of the animal. You would be surprised to know that there are elaborate rules to deal with how the different animals or the various animals should be transported. Transport of animal rule, you see, it says it provides rule for transport of dogs and cats. These are very detailed rules, you see. Transport of monkeys. Then there are rules relating to transport of cattle, which starts from rule 46. So for transportation, you will see that a valid certificate by a qualified veterinary surgeon to the effect that the cattle are in a fit condition to travel by rail or road and are not suffering from any infectious or contagious or parasitic diseases, and that they have been vaccinated against rinderpest and any other infectious or contagious or parasitic disease shall accompany such consignment. Then rule 48 says that the veterinary first aid equipment shall accompany all batches of cattle. Further, it says that I'm not reading out each and every rule. It says that the average space provided per cattle in railway wagon or vehicle shall not be less than 2 square meters. The cattle shall be loaded after they are properly fed and given water. The cattle in the advanced stage of pregnancy shall not be mixed with the young cattle in order to avoid stampede during transportation. Sufficient feed and fodder with adequate reserves will be carried to the last during the journey. Watering arrangement on route should be made and sufficient quantity of water shall be carried. Adequate ventilations shall be ensured. Now, let us go to rule 56 because rule 55 is relating to transport by rail, and generally you see the cruelty does not happen while transporting the animals through the railways. The cruelty happens when the cattle are transported through goods vehicle. Now, for the transportation of a cattle by goods vehicle, there are very elaborate rules which is provided in rule 56. It says that the vehicle shall be a specially fitted goods vehicle with a special type of tailboard and padding around the sides should be used. Ordinary goods vehicle shall be provided with anti-slippery materials such as square matting or wooden board on the floor and the superstructure if the load should be raised. No goods vehicle shall carry more than 6 cattle. Now, this is the most important provision, that the goods vehicle should not carry more than 6 cattle. Now, invariably, we have seen in my experience that whenever a cattle is transported for butchering or smuggling, then they are mercilessly loaded in the vehicle. While the law says that more than 6 cattle should not be carried in a vehicle and there should be a minimum space of 2 square meters per cattle. And there should be arrangement for food, water and everything. Unfortunately, the cattle are transported in a very, very cruel manner. You'd be surprised to know that even 35 to 40 cattle are transported in one goods vehicle. Even a vehicle like Bolero, there are cases which I have handled where 6 to 8 cattle are loaded. So this is very, very important that not only in the goods vehicle, even in a passenger vehicle like Bolero, they are able to transport 6 to 8 cattle. So how do we prevent such transportation? What these NGOs do, one of the NGOs which I regularly work with is Dhyan Foundation. They have Gosala or animal welfare centers all across the country. They work in tandem with the BSF and their volunteers, whenever they see, because you see, generally this cattle transportation which takes place for the purpose of smuggling, they have a fixed route. So their volunteers keep track of such vehicles. And in fact, not only they, I am aware of them, there are many such NGOs who informs the local police that look, this vehicle is carrying the cattle in a cruel and illegal manner. So once such information is given, then what is the role of the NGO? So here, before I go further, it would be important to refer to Prevention of Cruelty to Animal Care and Maintenance Case Property Rules 2017. Now, Rule 3 says that the custody of animals pending litigation. It deals with the custody of animals pending litigation. It says, so you see, once you inform the police, or whether the police on its own has seized an animal which is being transported cruelly or which is being dealt with cruelly. So once an animal has been seized, because the law very clearly says that if any animal is treated cruelly, then such animal is liable for seizure. So once the animal is seized, then this rule, Prevention of Cruelty to Animal Care and Maintenance of Case Property Animals Rules 2016, which was notified in 2017, springs into action. So it says that if any animal is seized, then during pendency of the litigation, the custody of the animal should be given to an infirmary. Kindly refer to Rule 3B, which says that animal has to be housed at an infirmary, Pinjra Pole, SPCA, Animal Welfare Organization or Gausala during the pendency of the litigation. Now here comes the role of an NGO. The NGO can file a application, intervention application for custody after filing of the FIR. The first requirement is that an FIR must be filed by the local police. And even if you see many cases, BSF seizes the animal at the border, then BSF also is supposed to approach the local police station for lodging of an FIR. So once the animal is seized and the FIR is lodged, then a application under section 457 of the CRPC can be filed before the magistrate, and the custody can be sought under Rule 3 of the Prevention of Cruelty to Animals Care and Maintenance of Case Property Animals Rules 2017. Now, on custody, at the time of giving of the custody, it is necessary that the authority seizing the animal shall ensure the health inspection, identification and marking such animal through the jurisdictional veterinary officer deployed at the government hospital, and marking should be done by ear tagging or by chipping or by any less some advanced technology. So it is necessary that the animal is identified through some non-some method, and the health inspection of the animal is done. After that, the magistrate, while handing over the custody as per Rule 5, shall determine an amount which is sufficient to ensure to cover all the reasonable expenses which are going to be incurred for the transportation, maintenance, and treatment of the animal based at the Gosala to which it is given, or an animal welfare organization to which the temporary custody is given during pendency of the litigation. So the accused may be the driver of the vehicle or the owner of the vehicle or the owner of the cattle who comes forward to claim the ownership. They are supposed to execute the bond to ensure that the cost of the maintenance of the animal and the transport of the animal to the Gosala is taken care of. And the animal welfare organization or the Gosala can draw upon such bond on a fortnightly basis to recover the cost incurred for the maintenance of the maintenance and care of the animal. Further, the law also says that the vehicle which is used for the purpose of such an offense shall be held as a security. So both things is important. If the animal is seized and handed over to a Gosala, at the same time the vehicle which is used for the purpose of some illegal activity is also seized, and it is kept as a security with the police officers. Now it is very important that a intervention application is also filed by the NGO who is seeking custody of the animal, that the vehicle should not be handed over back to the transporter, because if the means of the commission of such an offense is frozen, then obviously such cattle smuggling will reduce in the time to come. So we endeavor that not only the animal is seized and handed over to the Gosala, but we also try our level best to ensure that the vehicle which has been used for such offense is also seized and held as a security. Now, you see, one may ask the question, now what happens usually in such cases, that whenever you see we file such intervention application seeking custody of the animal, then the owner of the cattle comes forward before the magistrate. He says that, look, I am the owner. I am not involved with the crime. I am not the accused. I am running a dairy farm, or I am a agriculturist. So please hand over the cattle back to me, and I will ensure that the cattle are not butchered and they are taken care of. So I, being the owner, I should have the primary right over the Gosalas. In many cases, it is, in some of the cases, it is seen that the magistrate hands of the cattle to the owner on the ground, that the animal owner has a better right over the Gosala. And while doing so, they usually rely upon a old 1988 judgment of the Supreme Court in the case of, I'll just share the citation. One second. I'll share the citation in the chat box. It was in the case of manager Pinjarapol Devdar versus Chakra Morarji and others, reported in AR 1998, Supreme Court 2769. Therein, the Honorable Supreme Court interpreted that the law uses the word may, because section 35 says that the custody of the animal may be given to the custody of the Pinjarapol or Gosala or animal welfare organization. But we need to appreciate that this judgment of 1998 is no more relevant in the present context, because at that point of time, this Prevention of Cruelty to Animal Care and Maintenance Case Property Rules 2017 was not in existence, and the detailed manner in which the case property pending trial should be dealt with, such as the manner of the seizure of the animal, interim custody, cost of care and maintenance, holding the vehicle as security, and all these aspects were not there in existence. And in fact, thereafter, several judgments of the Honorable Supreme Court has also come. One of the very important judgment of the Honorable Supreme Court is a very recent judgment of 2020, wherein Honorable Supreme Court elaborately dealt with transport of animals rule 1978, prevention of animal cruelty, and came to the conclusion that during pendency of the litigation, the custody of the animal cannot be given to the accused. It has to be given to an animal welfare organization, Gosala, or any animal welfare organization. Now, the another question which arises is that why the custody of the cattle should not be given to the owner if he comes forward. Now, relating to this, it is very important to know that section 11 subsection 2 of the Prevention of Cruelty Act 1916 very clearly says that the owner shall be deemed to be an accused. So even if the owner has not been added as an accused in the FIR, as per section 11(2), he will be deemed to be an accused. And once he is deemed to be an accused, then there are not only judgment of the Supreme Court, which just I read out, there are judgments of the various high courts, which have clearly held that during pendency of the litigation, custody should never be given to the accused. Now, one of the judgment which I would like to read out is judgment of the Honorable Tripura High Court, a very recent judgment of 2021. I am just sharing the citation over here. What does it say? It says that under the Prevention of Cruelty to Animals Act 1960, that during the, as per the Act and the rules, the custody of animal in respect of which an offense under the Act has been committed should not be given to the accused pending litigation. Rather, the right of the owner shall stand forfeited if he is convicted or if he pleads guilty to offense. Section 11(2) of the Act is unambiguous terms provides that the owner shall be deemed to be committed an offense if he fails to exercise reasonable care and supervision for preventing cruelty to his cattle. Therefore, if any cattle is transported in a cruel manner, then the custody can never be given to the accused or the owner, and it should always go to the custody of a Gosala or animal welfare organization. Another issue which frequently arises is that in a criminal matter, third party has no locus, because once a criminal offense is committed, that it is between the state and the accused, and third party should not be allowed to intervene and play any role whatsoever in any criminal matter. So here there are two judgments, one of Patna High Court and another of Allahabad High Court, which has extensively dealt with the issue of the locus of NGO or a citizen of the country. I've shared the citation in the chat box. These judgments very clearly say that the Prevention of Animal Cruelty to Animals Act has been enacted to prevent the infliction of unnecessary pain or suffering on animals. And there is no doubt that Apex Court in various judgments have held that the third party is no locus standi to file criminal revision petition against the judicial order, as the third party is neither complainant nor aggrieved party. But the Prevention of Cruelty Act has been enacted to prevent the infliction of unnecessary pain, and the directive principle of state policy enshrined in Article 1448 says that the state have endeavored to prohibit the slaughter of cows and calves and other milch and draught cattle. Therefore, if any animal is put into cruelty and state fails to protect the animal, even a stranger to the proceeding being Indian citizen has every right to take legal recourse to prevent the cruelty towards the said animal. So, therefore, the courts have held that since a citizen has a fundamental duty to prevent infliction of pain around the animals, therefore, any NGO or a third party who has the zeal and mission to come to the court and bring to the notice the matter of animal cruelty, they should be heard and they should not be thrown out on the ground that they are third party. Now, in this respect, there is a judgment of the Odisha High Court with respect to the rules that the vehicle during the pendency of the litigation should not be released in favor of the accused. That judgment of the Odisha High Court, the relevant judgment citation I have shared in the chat box. Now, one of the most important judgment in the field of Animal Cruelty Act is the judgment of 2014 Honorable Supreme Court in the case of Animal Welfare Board of India versus A. Nagaraja and others. Now, this particular judgment was in the context of prevention of that Jallikattu, which was a kind of a festival being celebrated in the southern states, and it used to result into a lot of pain and cruelty upon the animals who were used in such festivals. So, Honorable Supreme Court dealt with the various aspects of the cruelty to the animals rule and made some very, very important observations, I think, which we all must know. The court said that PCA Act is a welfare organization which have to be construed bearing in mind the purpose and object of the Act and the directive principle of state policy. It was said that it is a trite law that in the matters of welfare legislation, the provision of law should be liberally construed in favor of the weak and infirm. And the court should be vigilant to see that the benefit conferred by such remedial and welfare legislation are not defeated by subtle devices. Court has got the duty that in every case where the ingenuity is expended to avoid welfare legislation, to get behind the smoke screen and discover the true state of affairs. Court can go behind the form and see the substance of the device for which it has to pierce the wheel and examine whether the guidelines or the regulations are framed so as to achieve some other purpose than the welfare of the animals. The court further said that the court should not hesitate to strike down any attempt to dilute or defeat the welfare legislation and the constitutional principle. The court also said that it is a duty under the doctrine of parens patriae to take care of the rights of animals, since they are unable to take care of themselves as against human being. Now, one of the very other important or the new principle which emerged in this judgment, it says that Article 21 of the Constitution, while safeguarding the rights of humans, protects life. And the word life has to be given an expanded definition, and any disturbance from the basic environment, which includes all form of life, including animal life, which are necessary for human life, fall within the meaning of Article 21 of the Constitution. So the benefit of Article 21 of the Constitution, in fact, the fundamental rights were extended to the animals also. In this context, it would be important to know the historical background of the Article 48, that in the Constituent Assembly, when the debate was being done to have the prevention of cow slaughter as a fundamental right in the Constitution itself, then it was said that the Article 21 fundamental right applies only to the human. It does not apply to the animal. So that particular provision was sent to fundamental duty under Article 48. But fortunately, the Honorable Supreme Court has interpreted Article 21 to extend the benefit of such right to animals also. So I think this is a very, very useful and important judgment in this context of animal welfare laws. Now, before I conclude my talk, I would just like to recapitulate what I discussed. What I say is that if any cruelty to the animal in any form, whether in transportation, whether to the cattle or to any other animal, is done in any form, then we as a citizen should immediately inform our local police station. The local police station will file an FIR. Once the FIR is filed, then any welfare organization or NGO can come forward to take care of the custody of such animal who has been treated cruelly. And for that, there are very, very elaborate laws which I have dealt in very, very brief, that during pendency of the litigation, the custody of the animal should go to such animal welfare organization. And once that is done, then automatically, if any cattle is whether treated cruelly in any illegal slaughterhouse or in the course of the transportation, then the large scale cattle smuggling which takes place can certainly be reduced to a large extent. So while there is BSF to guard the borders to prevent cattle smuggling, we should guard our internal borders. We should be vigilant to see if cruelty in any form, whether in transportation or otherwise, is taking place anywhere. And if it is so, we should perform our fundamental duty and ensure the well-being of such an animal. Now, I once again thank Vikas ji for giving me this opportunity. And with this, I conclude my talk. Thank you very much.
Thank you, Mr. Vinay. As it was a very niche area, and to give an insights to especially the animal lovers, we've always been hearing about what initiatives were taken under the patronage, or what we can say with when Maneka Gandhi was in the helm of the affairs and thereafter. But to understand the law and there are very limited issues. So we see Article 48, Article 51, but the dynamism, if one sees on a platform, one has the more insights. If I will just take a question as to what career you feel that an advocate, because a lot of people will feel, has one in this law of animal cruelty, what scope do you feel? Or like you said that the participation of an NGO in such a phase is good. So how NGOs can actually bridge the gap between the society, the legal fraternity as such, so that people are more sensitized as well as understand. Because we are talking of cattle, we hear a lot of issues regarding the after this dogs, etc. How you have to control. There's very limited litigation in respect of the cruelty as such. What do you feel as such?
See, I feel that I don't think that one should take up this practice in this branch of law as a matter of career, because as you said that if you want to take up exclusively practice in this particular branch of law, then I don't think it is so well paid, because mostly the NGOs comes forward to ensure the implementation of such laws. And I, in my personal capacity, I do all such matters pro bono. I don't charge any fees. Rather, most of the time, I end up spending some money from my pocket to file the petition, or to see sometime in traveling also, because they do reimburse a part of the traveling cost, but sometimes we ourselves don't charge them. But yes, of course, at the magistrate level court or even at the high court level, there are advocates whom we engage and we pay them also. But the NGOs, you see, they are mostly more concerned with spending money in taking care of the animals to maintenance of the Gosala, and they always they try to have a understanding with the lawyer, either to charge less or to charge it to the minimum. So if anybody who wants to practice in this particular branch of law, if they have a passion for the welfare of the animals, if they want to take it up as their duty as a citizen, or to perform their fundamental duty as a citizen, I think those sort of lawyers, mostly they are there in this field, who are animal lovers, or who wants to have some sense of their responsibility as a citizen. But as a career, there are very few.
Yeah. So the takeaway from Mr. Vinay Shraff is that if you have a passion to pay back to the society, or what we say, what are the rights, we all speak of the rights of a citizen, but as even the latest Supreme Court judgments have said, that we all speak of our rights, but we do not much speak on the duties. As what Lincoln said, do not ask what the country does for you, but at least ask what you have done for the country. So point well taken, that if you want to pay back to the society, this is a career where you can actually pay back. NGOs can become more active and do participation of sensitization of the society at large. Like we have talked about cattle. The monkey manance is also one where we see a lot of litigation as to how the monkey manance can be done, because there are very few takeaways as to how it can be prevented. They are old theories. Like I also defended a case on behalf of the administration of UT Chandigarh. They are not as such very regulated instructions. You have to go by pamphlet sensitization or by the beat of the drum. But it's eventually how you actually carry the message and people get improved, and more of the reading skills habits will definitely improve. So thank you, Mr. Vinay, for sharing.
Just one last thing I would like to say, that you see, anybody who is watching your show on YouTube or here, and they wish to do anything anywhere in the country to help implementation if this law, if they want to know further about the nitty-gritty of this law, how to file the petition in the court, how to go further, what to do if suppose magistrate rejects, then how to move the session court or high court, then I am there to help. I can help them with the draft petition. I can help them with the understanding of the law. I can help them on a one-to-one basis, personal basis, not necessary that there should be a large gathering. This is the first opportunity which I have got on a big platform like yours, but I am always available for anybody who wishes to come to practice in this branch of law. Thank you.
Thank you, Vinay. That's a very kind gesture. We have also filed one petition. Our chambers have also filed a petition in respect of as to the rights of the kennels and all, how they can be protected, and those who are actually breeders for that. We have filed a petition because there are certain challenges that the rules are dehors of the main act. So let's see, notice has been issued. Union of India has appeared, State of Punjab has appeared, how things shape up. So everyone stay safe, stay blessed. And tomorrow we start a series on the part of pleadings. Tomorrow it will be a simplicity and overview of pleadings. And Justice Pradeep Nandraj Jog, a former Chief Justice of Rajasthan High Court and Bombay High Court, has been kind enough to take this into 5-6 parts of the series. So do stay connected with us on the social media. We are posting it tomorrow. It's 5 p.m. Everyone stay safe, stay blessed, and prevent the animal cruelty. That's the bottom line of the today's webinar. And that is in tune and it syncs with the obligations casted upon the citizen under the Constitution of India. And there couldn't be a better homage to the two greatest sons of the soil, that is Lal Bahadur Shastri and Mahatma Gandhi. And what a way forward to pay a tribute to them. And as we see, this government of ours is also taking a lot of initiatives. Today is all social media, the Prime Minister taking it to the front, highlighting all those aspects. Thank you.
Thank you very much.